And I would, in that case, give Professor Louise Ellen Teitz the floor to conduct this session 2, which will focus on the benefits of the convention to businesses and practitioners. Louise Ellen, the screen is yours. Thank you very much.
Thank you. Thank you. Can you hear me okay? Yes, good. Hola, and welcome to the second panel, which looks at the practical and legal aspects of the Choice of Court Convention with a focus on the Americas. As you heard, the Choice of Court Convention serves both as a dispute resolution litigation tool and as a transactional planning tool. We thought we'd start by seeing what the current situation is in 4 countries in the Americas in the treatment of foreign judgments without the 2005 or the 2019 convention. For instance, in the US, we have a big trade imbalance that we allow one readily to import most foreign judgments, but exporting them is more difficult, which, as Professor Hartley mentioned, was a motivating factor for the US to push for the Hague Conference to work on judgments. And that work culminated first in the Choice of Court Convention. I'll turn to Trevor Carmichael, who maybe could start us off with a brief statement on the situation with foreign judgments in Barbados. Trevor? Trevor?
Can we unmute, please, Sir Trevor?
Maybe while we are trying to get Trevor unmuted, we could go to Nadia and then come back to Trevor, perhaps? If that would work?
If you want, I'm here.
I think maybe that would work.
Thank you. I was actually muted from somewhere else. So someone has unmuted me, but I was unmuted here, but not over there. Sorry about that. Well, good morning, and thank you, Madam Chair. And I'm delighted to be asked to give the Barbados position. And essentially, in Barbados, we have an act which is called the Foreign and Commonwealth Judgments Reciprocal Enforcement Act. And that is really the legislative framework which governs the enforceability of foreign judgments. As can be gleaned from the name of the act, foreign judgments may be registered and enforced in Barbados where the judgment was made in a jurisdiction with a similar recognition and enforcement provision as is the case in Barbados. And there are certain judgments that may be registered. They're restricted to judgments issued in the Superior Court of the UK, judgments obtained in the High Court of quite a few Commonwealth territories, and judgments given in the Superior Courts of any foreign country, provided that what used to be the Governor General, but what is now the President, is assured that similar treatments of enforceability will be given to judgments issued in the High Court of Barbados. Now, as Justice Anderson of the Caribbean Court of Justice pointed out, a foreign judgment is enforceable not only in Barbados, but in much of the Commonwealth Caribbean, only if it has been registered in the High Court. So registration in the High Court is required, and one can therefore go to the procedure for registration in the High Court and see what elements must be followed. The original court must have acted with jurisdiction. In other words, no judgment will be registered where the original court did not act with jurisdiction or acted without jurisdiction. The judgment debtor must have been resident or ordinarily resident within the jurisdiction of the original court. The judgment cannot be obtained by fraud. And there again, as Professor Justice Anderson pointed out, this is very much almost like suggesting that you must come with clean hands. It's very much like the equity position. Furthermore, no judgments which took place as a matter of against public policy will be entered or registered, and this, in a sense, again, and it reflects the learning enshrined in the New York Convention. There is a procedure, a very detailed procedure for the judgment creditor to apply to the High Court in Barbados, but it must be done within 6 years after the date of the judgment, or where an appeal is pending, after the date of the last judgment. So there is that procedure. Furthermore, the judgment will only be registered if the judgment is final and conclusive between the parties. There has to be a finality about it for obvious reasons. It will only be registered where a sum of money is made payable, which does not include monies in respects of taxes, charges, a fine, or a penalty. And you can understand very well the public policy reasons and the uncertainty reasons which that seeks to recognize and accept. Now, once the judgment has been registered in the High Court, the judgment creditor may then take steps to enforce the judgment, and no proceedings will be commenced by way of execution until the time limited for setting aside the judgment has elapsed. So that is also important. Foreign judgments may also be enforced under the common law, and that's important to recognize, because the theoretical basis of that action is that the judgment constitutes a simple contract debt arising out of the decision of the court to which the parties had implicitly agreed to submit their original disputes, and that is very important.
I wonder if in general most judgments have been enforced recently, just to get a general sense, or whether there is a problem.
No, there has been a great acceptance of the enforcement of foreign judgments, especially if practitioners follow the rules and bring them, within the ambit of the rules. They've been readily enforced.
That's good to hear. Nadia, is that true as well in Brazil? Is there ready acceptance?
Yes, and I would like to point out that in Brazil, both arbitral awards and foreign judgments go through the same process of recognition in the Superior Court of Justice, so they are considered equal. And 90% of all requests are granted, but I have to say that 95% of all requests are family law cases, and only about 4% are commercial cases. Notwithstanding, all of them pretty much are granted by our Superior Court of Justice. And all you need to do is have the requisites, formal requisites complied, and they would only see if it's not against public policy. So that's in general our rules of the Superior Court of Justice.
Okay, and let's turn now to Costa Rica. Mauricio, perhaps you could.
Hello, Luis. Following the invitation of the organizer, I am going to switch to Spanish.
Yes, that's fine.
En Costa Rica, el reconocimiento de las sentencias extranjeras.
Recognition of foreign sentences is used, it goes through a code that we have. There is an institution which is quite old, dates back to 1928, in fact, but in practice, it isn't used much because there are very few countries that have ratified it. And the countries that have ratified it, such as Costa Rica, tend to use it very little, as long as it doesn't contravene national legislation. So essentially it's a national treaty, an international treaty, which is applied under law. There is a link. So in practice, in reality, this type of procedure is regulated by the civil procedure from 2018. Then Costa Rica ratified the majority of sentences, but the majority of cases that go to the courts relate to family matters. But the cases that are submitted, commercial affairs, for example, and foreign matters, are recognized in the majority of cases. The only extra thing is that in the new legislation that came in 2018 for civil cases, there is a particular characteristic now established saying that sentences that are recognized must not contravene national public order, the law, national public law enforcement. And that has undergone some criticism in the country because this is the introduction of this new concept. It's a national competence, whereas in reality, it should be used on an international level. And we haven't yet had many cases that have shown the limits to these concepts of public order, public policy rather, nationally and internationally. And for cases from abroad, have to be under local legislation. So that is one of the effects of the ratification of this, when this concept was introduced at national level.
Thank you. And the interpretation is working on this end, so I'm assuming it's working for others as well. And then finally, Jose, perhaps you could follow up in terms of Paraguay and other parts of Latin America.
Thank you very much, Louise. I will also switch to Spanish. Can you hear me?
No,
No?
I can hear you, but there is no interpretation.
Sorry, the speaker temporarily muted himself, but as soon as he begins to speak, the interpreter will also speak.
Okay.
Okay.
I'm going to switch to Spanish, says the speaker. He's back. Well, I'm delighted to see that we have interpretation for this event with Spanish. It follows a tradition that began in 2012, when you had diplomatic conferences, diplomatic sessions, etc., when Spanish was added. And that was one of the principles of The Hague. And it's very, very important for us to have interpretation available where possible, obviously. Of course, there are always budgetary limitations, as with any organization, but Spanish is a very important language for the organization, especially given the enormous number of countries that are parties to the Hague Conference, which do use Spanish. So I'm particularly happy, and I would like to congratulate Christoph, Ignacio, everyone who has made this event possible, and to have Spanish interpretation during the event. And with regard to the situation in Paraguay, Paraguay has very modern legislation where arbitration is concerned. It's very modern, and also with applicable law, international contract law as well, following the Hague Principle. However, its procedural legislation from a civil and international level is somewhat acronymic. It's not very different from other countries in the region where arbitration is concerned, except for a handful of countries which are making progress in that direction. But I don't have any statistics to hand, no official statistics or studies. We don't have figures available about when sentences are applied in this way. The litigating parties feel it's relatively viable to hand down a sentence in this way.
Thank you. Good. Now that we have a little sense of the current situation, you are all from countries that have not ratified the 2005 convention. As am I, as Professor Hartley mentioned. In the US, we love the convention. We just have a problem of domestic implementation. But it would be interesting if we could hear what would make COCA more desirable for your country and encourage your country to become a contracting state, and what has held it up, perhaps. Why don't we start with Nadia from the view of Brazil and how it views the choice of court convention?
Thank you, Louise. I hope my microphone is better. And first of all, I would like to thank the HCCH for inviting me. And it's a great pleasure to be in this panel and to have heard my colleagues earlier. I have not had the opportunity to thank everybody and say hello formally. Brazil has no legal obstacles preventing it from becoming a contracting state to this Hague Convention, the Choice of Court Convention. To our knowledge, the Ministry of Justice has already issued a preliminary opinion favoring the accession of Brazil to the convention. And I was a part of that study. I helped draft the arguments, so I guess it will go well. At this point, according to our constitutional setting, we need the president, the executive power through the president, has to send it to Congress for approval. And it's not yet ready to send. I don't know why. I have to say that maybe because this is a very technical issue and maybe there's not like a popular outcry for it to go forward, and that is holding it back. But here in the private international law community, we have stressed the need for the convention to be taken by Brazil. So I guess we'll see that in the coming points, in the coming years, I hope. Also, another relevant point I would like to make is that Brazil is a party to Mercosul Protocol Buenos Aires on international jurisdiction in international contract matters, and that expressly allow for choice of court clauses, and it's currently in force in Argentina, Uruguay, Paraguay, and Brazil. So I can say that in the region, we're already moving forward towards accepting choice of law clauses. Our jurisdictions are more acceptant of this kind of clauses. For Brazil, we started out in case law, not accepting it at all. Even if we had a choice of court clause, courts would say they had jurisdiction and will go on. Since 2016, with the new Code of Civil Procedure, Article 25 expressly allow for choice of a foreign court if the parties has an exclusive agreement on this point. So this is a big change for Brazil. We already have case law where there was such a clause and where Brazilian courts have said, we are not the convenient court, we will not take the case. And the provisions limited to international contracts, which means in national relations, you cannot opt for another court. And the only limitation is if it is against Article 23, which is our article of the Code of Civil Procedure on exclusive jurisdiction. And that article is for immovable property located in Brazil, the sharing of property also located in Brazil, and cases of succession and divorce. Thus, it's very clear that if you have an international commercial contract, you have no problem enforcing a choice of court clause in Brazil. And so if you have chosen a foreign court, then Brazilian court, the judicial power will say they're not responsible for the case. One last point I wanted to make is that if it is an adhesion contract, a consumer contract, that is not going to fly. That Brazil will say they have jurisdictions most of the time. And so I guess we have a more favorable scenario, and Brazil should soon become a party. Although we do have Article 25, the convention has more details on the matter, and I think it will help put us in the world again. Thank you.
Thank you. And actually, of course, the convention doesn't cover consumers or succession, so it shouldn't be as much of a problem. So that's all good news. Jose, perhaps you could give us the view from Paraguay and on the acceptance of party autonomy in the convention, or what has held it back?
Claro, Luis. Bueno, yo estoy muy optimista con respecto a la
I'm very optimistic about the possibility of Paraguay ratifying this convention in the not too distant future. And I'll explain the reasons why. Paraguay joined the Hague Conference in 2005. So that was the year that Paraguay became a member of the organization. And during that time, it's been ratifying, it's been adopting quite a large number of interesting documents, in addition to attending the Congress for ratification of others. So there is a certain trend here with the country that it is incorporating these articles as it has been over time from the conference, from the Hague Conference. And what's helping here is the fact that the Hague Conference has a regional office, the one it has in Buenos Aires. It's a very efficient office. It's very close to the Chancellery, very close to the world of academia. And that has been viewed very positively when it comes to the importance of adopting these instruments. Something else that's really helping is the fact that even in the General Secretariat of the Hague Conference for Paraguay, we've had visits 2 times recently. And that's extremely important because given the high level that we're working at here, it helps us to keep working and keep making progress, consolidating its process of adopting the conventions. I've been listening in to a number of informal discussions and conversations, and there was one concern that has come up about choice of court convention, and that is the fact that here in Paraguay, we have a law which is designed to protect. It's called an institution contract. This is something that is quite special about Paraguay. There are other countries which have similar laws, even in Europe. Belgium, for example, has this distribution law or similar types of laws. And the concern is that this law subjects the main suppliers to Paraguay to a set of rules that would have to apply in the case of a dispute. Now, this really oughtn't to be a concern, given that the choice of court convention does have the reserve option available. Also, considering the fact that this distribution law in Paraguay respects the Buenos Aires Protocol, which Nadia mentioned as well, because Article 4 of that convention covers this eventuality. And the Paraguay court has sent to the Mercosur court a request to obtain information about the Buenos Aires Convention. Then, given the revision of Mercosur, it's quite a complicated document to read. But if I'm correctly interpreting it, it's saying that each country is sovereign when it comes to its own public policy reserves. So for Paraguay, this makes up part of the Mercosur Protocol as well, which does have that provision in it. But that also might be part and parcel of this universal instrument, such as the Choice of Court Convention. Also taking into account that Paraguay has a modern law on arbitration in place.
Thank you. And I think if we have more time later, but I think that your reference to Article 21 of the Choice of Court Convention, which does allow a declaration of specific matters to be excluded from the convention, might be of some use. Mauricio, perhaps you could give us a sense of how the convention will fare in Costa Rica and how soon it might come.
For sure. En Costa Rica tiene un rezago importante.
Costa Rica has adopted a number of instruments with regard to international commercial law. The country is always very swift to adopt all international treaties on human rights, for example, environmental affairs as well. But generally speaking, these topics are dealt with separately. There is a trend which we've seen emerging in the past 10 years, let's say, and that is the time since the country has been part of the Hague Convention. But in the past 10 years, we've had the model law, arbitration provisions, notifications abroad, etc. A number of provisions have been adopted in that time. And then 2 or 3 weeks ago, the country, it's pending ratification, but also signed the 2019 Convention about foreign rulings. Costa Rica signed the 2019 Convention first, before the 2005 Convention that we're also talking about. The fact that the country hasn't signed that 2005 Convention might be explained by a variety of reasons. There might be obstacles of a legal nature. In 2014, in fact, the Chancery sent to the General Prosecutor of the Republic a request to analyze the convention to see whether it was appropriate, whether there were any disadvantages, and that was the request that was sent, and it was a request to analyze all of these aspects that we're discussing. It was decided that there were no limitations in place or no obstacles to it ratifying, but the country will have to adopt the declaration as foreseen under Article 19 of the Convention, which limits the competence of courts in Costa Rica when there isn't sufficient connection with Costa Rica. That's a question of domestic legislation, civil procedures as well, and decided upon before 2018. So that, but a Costa Rican court can decide not to hear a case when there's not a sufficient connection with the country. As far as the distributors are concerned, as mentioned by José Antonio, that's one example. But aside from that, there is a presumption in this law that these matters
entiende que quieren ser resueltos mediante arbitraje.
Need to be resolved via arbitration. And it establishes that these cases, this form of arbitration, can be resolved in Costa Rica. So arbitration can take place in Costa Rica, but not necessarily. This law is considered to be a law under public policy, which means that it can be applied by any foreign court. It can be applied by a foreign arbitration body as well, whilst respecting law, public policy law. But it seems to me that the convention is very useful for the country, especially because, as I was saying before, it regulates certain issues when it comes to mutual recognition of foreign rulings.
De 1928, de muy poca utilidad, y por unos pocos artículos.
Some of our provisions date back to the 1920s, and so
tan escasa de esta materia,
there's very scarce legislation on this subject, which doesn't really reflect Costa Rica's stance, which has free trade agreements, for example, with the United States, with Canada, with Mexico, etc., China, with Europe, the list goes on. It's a very open economy, Costa Rica, and it really needs to have a better regulatory framework in place for foreign trade. So at some stage in the near future, especially given that we're just starting now with this ratification process of the 2019 convention, then we could also include the 2005 convention.
Yes, it sounds like you're on your way with 2019, and then with the 2005, you'll be able to fill in the gap for the exclusive choice of court, since they work well and were designed to work together. Trevor, perhaps you can tell us about Barbados and whether you see the convention being likely to move forward quickly, or what might make it more appealing.
Well, thank you again, Louise. I think in speaking about Barbados and the convention, one has to consider Barbados's emergence, if I will put it that way, as an international business center. Over the last 20 years, Barbados has pursued a very vigorous international business policy. We have a large number of double tax treaties, and therefore, increasingly, we are putting ourselves further into the scope of international business. So within that framework, I see the convention as assisting Barbados in developing its business center, its international business sector, and making that sector more efficient and more attractive, and making it more of a global service hub. The convention, under the convention, the judgment of the chosen court will be recognized and enforced by the courts of other contracting states that would have ratified the convention. They may also be double tax partners of Barbados. Now, our current framework for the enforcement and recognition of foreign judgments, as I mentioned earlier, has a limited geographical scope. Even though there are only 32 contracting states to the convention to date, the bulk of which are EU members, nevertheless, the geographical scope under the convention surpasses the geographical scope under our reciprocal enforcement judgments act. So that is another advantage. The convention obviously provides uniformity and predictability in connection with the choice of court clauses. Parties would not run the risk of spending time and money litigating jurisdictional issues. Again, that would be very helpful. And during contract negotiations, the parties can easily identify which countries are the contracted states and make a selection with the assurance that the rules of the convention will be applied. And that's another advantage. So for these reasons, it would be beneficial for Barbados to join the convention, and I support it strongly. However, there are certain changes that we in Barbados will have to make to our own legal system we presently have a backlog of court cases. We have to tidy up that backlog, and we have to make further improvements in our own business operations, such as streamlining our operations at the corporate registry and the intellectual property office. So these sorts of things will need to be addressed from internally and strengthened. But putting all of it in perspective, becoming a member of the convention will help us also to move forward in the swift administration of the courts and administration of justice. And I do not think that, as it is, our administration of justice would undermine the functioning of being a member to the convention. And I personally will, as a senior advocate, the senior counsel, will pursue advocacy that we move towards getting involved and becoming a member of the convention. Thank you.
Thank you. And actually, you've given us a lovely segue to our next question, although I think we have limited time, but you have in fact given us reasons why you would encourage clients, obviously, to put choice of court clauses in contracts and to use litigation rather than arbitration. But I will ask Jose for just some short comments on that, and then I'll try and catch everyone else before we run out of time. As this was referred to earlier in the discussions in relation to Gary Bourne, but it's one that keeps coming up, whether why you should use choice of court clauses and therefore, of course, the convention as opposed to arbitral clauses. Jose?
Gracias, Luis.
Thank you, Louise. I am a member of the Arbitration Court at the International Commercial Court, and we operate under this mechanism. I'm a member of the Permanent Arbitration Court of The Hague and an active arbitrator in there. And also I intervene where investments are concerned. I'm a member as well of other arbitration courts as well, for football. And I've regularly intervened in arbitration matters in various countries, in South America and in Paraguay. I am a huge fan of arbitration. But I'm not here really to talk about arbitration. I'm here to talk about the decision on deciding or allowing the parties to decide their preferred forum, their preferred court, the court that they would prefer to take their dispute to. And in that sense, the choice of court convention can be an excellent instrument to ensure that the parties can make that choice, can make a real choice, and ultimately a choice which offers legal certainty that is going to be upheld. I'm talking here from the perspective of a lawyer who is frequently there to advise international transactions in Paraguay. I'm not really involved in the theoretical side. It's more the practical side where I intervene. And I'm not going to pretend to be an expert on international civil matters. I'm a professor of arbitration as well, but not so much for litigation. Although on many occasions, clients prefer litigation to arbitration, and we have to explain the pros and cons to them. And ultimately, it's the client who has to make that call. And then there are questions of cost as well, because I believe that Professor Hardy mentioned this right at the beginning. Arbitration costs a lot of money. Now, on many occasions, an explanation is given that the costs of arbitration have to be weighed up as a whole, have to be taken into account from an overall perspective. If you think about various years of litigation, that comes at a cost as well. And there are costs of legal representation in litigation as well. But that has to be explained to the client. Then the client decides. So the choice of court convention gives people the ability to decide and legal certainty as well, so that they know that that decision that they are making and they're given the expectation is effective, and to ensure that whatever is decided upon is upheld. This supposed rivalry between arbitration and litigation actually really damages arbitration, because this resistance to arbitration, especially in countries such as countries in Latin America, where they have to consolidate. And you also have to understand that when consolidating arbitration, the judges have a fundamental instrument. Arbitration needs the judges. Judges have are the ones who have to apply arbitration. They're not enemies of each other. When trying to defend arbitration and saying that it's the only mechanism that would work for international commercial disputes, for example, all you're doing essentially is alienating or moving away from the conditions that would really allow the client to view arbitration properly. It's not a good policy, pitting the two against each other, because they actually go hand in hand. And essentially, it's up to the parties to decide, depending on the case in hand, whether they are going to opt for arbitration or whether they prefer litigation. Now, just very quickly, just responding to the criticism of Garibald. Garibald, I've been reading for over 20 years now, reading the what has been written, and there's been some excellent work produced. But I disagree with what he says at certain points. I've read the criticism, and the criticism is issued that there are many corrupt courts. Now, this is an important point, but again, arbitration, this is where arbitration and litigation can go hand in hand, because if this legal system is corrupt, then it's not a good environment for arbitration either, but it's not good for implementation either, because a judge might be able to interfere when it comes to implementation. So the same argument about corruption works both ways. There's a problem that some countries in Latin America have, where their judges are perceived as being corrupt. And what is the consequence of that? That the parties don't choose those countries for the seat of arbitration. So that's an important point to drive home there, that the two go very much hand in hand. And so if we're saying that if corruption is a problem, it's a problem for everyone across the board, both for on the litigation side and the arbitration side. Now, I have jotted down a number of other points that I wanted to make here as well, but I think I've picked out the most important. I would also just like to conclude by saying that a convention, when you're negotiating a convention, you don't always obtain the ideal result, the perfect convention. Ultimately, the convention is a result of a series of compromises that have been made. And we have this dream. And I'd just like to show an image here on the screen if I can. This is one of my photos with Arthur von Meren when he was my PhD supervisor at the university that I attended in the United States. I just wanted to pay tribute to him and say that he also had this dream, and part of that dream has come true in the form of this choice of court convention. In addition to, aside from talking about corruption with a handful of judges or whatever it might be, I would like us to talk about arguments and what goes into this choice of court convention. It offers a fundamental amount of value, and this person was a professor of international litigation and arbitration. He was a professor at my time. He was the benchmark across the world for a benchmark, and that continues to be the case now.
Yes, thank you for reminding us about Arthur, who we often refer to the convention as Arthur's baby, because he was with us till almost the end of the signing. And it is very much a tribute to Arthur von Meren that we have the choice of court. And I would be remiss if I didn't also mention that the convention has often been described by another longtime participant in the Hague negotiations, Peter Truboff, as the middle class litigants opportunity, that arbitration works for large, big transactions and companies, but the middle class litigant needs an alternative, and choice of court is indeed that alternative. I know we're running out of time, but I did want to respond. We had a question earlier from one of the countries, I believe, to the survey about whether electronic commerce and electronic transactions were impacted by the form requirements, or what impact the online and electronic commerce aspect has on the choice of court convention. And I was hoping Mauricio might be able to respond to that.
Sure, Luis. En efecto, un tema que sigue dando...
Well, indeed, a topic which continues to create headaches for a number of countries, including my own, is this written convention requirement, which the number 58 covers. It also requires us to make amendments to the model law that was passed a few years previously. And I think that given that situation, I believe, well, at least in the 2005 convention, there was Article 13, number 2, that talks about exclusive agreements for choice of court, which can be documented not only in written form, but using any other means of communication that might make that information accessible for for subsequent consultation. In order for it to be for the convention to be approved in 2005, it could have been a little bit more explicit when it comes to covering electronic documents. And as has been mentioned, negotiating a convention isn't easy. We see that it's always the result of a compromise, but this was a very abstract exercise, one which might have offered a greater level of clarity. For example, when talking about documents or agreements being documented, perhaps there could have been a better choice of word there. I think the concept of electronic communications could also have been included there, saying that all types of communications used to exchange information ought to be considered, and that also would be a valid way of reaching agreements. This applies to other international mechanisms as well. E-commerce law from 96, 2001 on electronic signatures, one on electronic communications, on international information, which was also approved in 2005. But at any rate, these types of agreements, when it comes to choice of court, they might not be perfect on electronic means, but they also apply exclusively to B2B operations, business to business, because these transactions that take place with international trade use electronic commerce. If it were B2C operations, they would be excluded from the scope because that would be for a consumer. There's also the requirement to approve a convention with regard to how perfect the wording is. So if they are valid, or they're only if they can be valid when an agreement is clicked, as is the case for many courts, or there could be some type of other requirement. It's not just a click agreement. There can be other types of agreements made, but these have been covered by different courts in different regions. And generally speaking, it's understood that when there is the will in place, if there is these one-click agreements, they are valid. I'm not aware of any limitations there where choice of court is concerned, where you can perfect the agreement electronically.
Thank you. And that gives us a lot to think about. And maybe the next aBridged might look at the 2019 and some of the changes we made to deal with changing problems and the two conventions working together. So lots to think about. And I want to thank the panelists for helping us to see all the progress being made and the chance for the future for certainly Latin America and the Americas to make use of the convention. Thank you.